Welcome to the classroom. Please like, share, and subscribe to our channel.
For the newly formed government so loved its people that it sent its many legal writers and advisors to create legislation that would forever govern the harmonious relationship between employer and employee, trade union, and bargaining council. The Labor Relations Act of 1996 does all of that and more. It was designed to redress the unfair treatment and the imbalances of the past created by the apartheid regime. Grievance procedure. This is the stipulated route in which an employee must submit a complaint. The employee must first talk to the supervisor. If they do not feel comfortable with this or there is a trade union, then they will talk to the trade union representative. The matter will then be discussed with the departmental manager or the department's representatives. If the matter is still not able to be dealt with, then it goes up the different levels of authority throughout the company. If problems still persist, then the issue will be referred to the different agencies, whether private or the bargaining council, and then up the ranks through to the CCMA, the labor court, or the labor appeal court. Wherever the matter gets resolved and both parties reach an amicable decision, that is where the process stops. However, if both parties believe that they are right and they cannot find any common ground, then the process will go the course of the grievance procedure. Okay, for a second, let's go back to the Labor Relations Act. The purpose of the Labor Relations Act is to: 1. Promote fair labor practices. 2. Promote collective bargaining. The main objectives of the Labor Relations Act are to enforce the fundamental rights granted by Section 23 of the Constitution, to enforce South Africa's international obligations as a member of the International Labour Organization, to provide a framework for collective bargaining between trade unions and employers, and to promote effective resolution of labor disputes through employee participation in the decision-making in the workplace. Remember, as per usual, legislation will have a positive and a negative impact on any business. So the positive impacts that the Labor Relations Act will have on the business is that it could promote healthy relationships between employers and employees. It looks to protecting the rights of the business and its employees. And most importantly, it tries to quickly settle labor disputes. Negatively, this act will definitely increase the cost of hiring labor. And this then makes it so that businesses become less competitive on a global scale. Sadly, it could also mean that employees could talk about sensitive business issues to their trade union representatives. Labor disputes are time-consuming. If this happens in your business, you will lose a lot of labor time. I have been of the opinion that the LRA is a little bit unfair towards business because it makes it nearly impossible to fire an employee who is doing the minimum requirements. However, that is just an opinion of mine. The penalties for not being in compliance with the Labor Relations Act are: as an employer, you will be forced to enter into dispute resolution processes, and this could prove to be very expensive and time-consuming for you. The worst part is that a process like this could have a huge impact on the morale of your workers, thus affecting productivity. Your business may be fined penalties for non-compliance. Not only this, there may be financial costs linked to the non-compliance. If you are taken to the CCMA or any institution that could deem that you are in the wrong, as a punishment, they will impose a financial punishment on your business, where you must pay the worker or workers which you have wronged. What can be seen as discriminatory as far as the Labor Relations Act goes? If you, as a business, choose to promote the interests of one trade union over another, remember, things have to go with fairness, and choosing one organization over another because of any reason whatsoever could be viewed as discriminatory against the workers. Dismissing employees unfairly or without due process may be seen as discriminatory. Another thing to remember is that this act provides for the freedom of association. So if you choose not to allow workers to associate freely or join their trade unions of choice or workplace forums, you as a business are acting in a discriminatory manner. This then begs the question, how can my business then try to comply with the Labor Relations Act? Well, it's quite simple. Avoid unfair dismissals by following due process as prescribed by the LRA. Also be careful of promoting people above others without following proper procedures. Allow employees the right to association by allowing them to form trade unions where they may exercise their rights by making workplace decisions which may also have an impact on them. Another big part is to allow for the establishment of workplace forums where discussions may be facilitated. Let's talk about the rights that the employees and employers may have as per the Labor Relations Act. The employees have the following rights: the right to join any trade union of their choosing, to request representation on any issue that they may be impacted or affected by. Trade union representatives may take time off of work for their duties. They have the right to embark on legal strikes. They may refer any disputes to the CCMA. They may refer any unsettled disputes to the Labour Court or the Labour Appeal Court. You as an employer have the following rights. You may lock out employees during strike actions. You may join employer organizations which are somehow similar to workplace forums but with employers of the same industry. Employers may join and negotiate terms and conditions through bargaining councils. Employers may dismiss employees who have taken part in unprotected strikes. During a strike, employers may enforce the no work and no pay rule, which essentially means that as long as your employees are striking, you may choose not to pay them for that time frame. So essentially, the Labor Relations Act tries to resolve disputes as quickly as possible. It attempts to do this in a two-step approach. The first step would be conciliation, where both disputing parties talk it out in the presence of a neutral third party. This third party or the conciliator will not decide who is right or who is wrong. Rather, they facilitate the discussion so that they do not devolve and become unmanageable. So if this first step proves unsuccessful and no agreements are reached, then the Act says that we must move on to the second step, which involves arbitration, adjudication, or industrial action. Mediation would be the process of making a recommendation to the parties. If the recommendation made by the mediators does not work, then arbitration will happen. This is when a neutral third party makes a decision about who is right and who is wrong. This is a binding decision on both parties. If the involved parties still feel that the decision is not fair, they then refer the matter to the Labour Court. This is called adjudication. And if that decision is not appreciated, then the Labour Appeal Court is where the matter will finally be settled.
This is the end of part 1. Thank you so much for watching. Part 2 will be up shortly, so stay tuned for that. If you haven't subscribed, please do so by clicking our subscribe button and turning on post notifications so you never miss out on a video.